We are tracking developments in the trial of 3 Tacoma police officers in the death of Manuel Ellis. Thanks for joining us. I'm Christine Pay. Ellis died while being restrained by police in March of 2020. Officers Matthew Collins, Christopher Burbank, and Timothy Rankine are all facing charges in his death. King 5 is live streaming the entire trial from opening to closing statements. We take you now to the courtroom live.
We had a little bit of a conversation. We got on the record. The state is not going to call any rebuttal. So I guess our plan is to bring the jury out, say all that on the record, so they know that. We've got these, we do have these exhibits we've still got to deal with, and I'll mention that to the jury. And then we'll take the rest of the afternoon to work on that and hopefully get it completed. And then I'm hoping then that we would, and as we discussed briefly before we took a break this morning, we would likely then recess till Monday with the jury, and then tomorrow we would work on, have another jury instruction conference because we didn't complete it before. And there's been some additional instructions submitted, at least as of this morning, which I haven't had a chance to look at because I've been with you. So it'll take us a little bit of time to get through that, and then hopefully we get all that accomplished in terms of having discussed all that, and then I can make the decision about what is going to be part of the instruction packets, and we can make copies for you all. And I'm hoping that maybe, I don't know that we're going to be able to get that accomplished by tomorrow afternoon with all of that. If we do, that's great, but I'm not expecting it. But I am expecting that we at least get done with essentially getting through all of that so that I can make those decisions by the end of the day or overnight, and that on Friday afternoon we could have you all back, if you guys are available, to then give you the court's proposed instruction set, and you can make your exceptions to the court's instructions and or the court's failure to give other proposed instructions. And so I'm not expecting that we can be, I'm not expecting, we'll be obviously on the record for this afternoon's proceedings with respect to these exhibits. We would not be on the record with respect to the jury instruction conference like we were last Friday, but it will be an open courtroom, just as it was last Friday. And then Friday afternoon, if we stay on the schedule, then we'll be able to be back on the record to do the instructions, to do the exceptions rather. Which by then, of course, none of you will have any exceptions. You'll be just thrilled with the court's proposed instructions. Mr. Hauser.
I agree. I have one question for the court. So my client lives in Oregon. We're at recess the rest of the evening. Once we finish today, he doesn't have to appear tomorrow. His presence for exceptions on Friday afternoon. He doesn't have to drive back up to Oregon, just to drive back down on the weekend.
If he wants to voluntarily absent himself, he may do so. But understanding we're going to proceed in his absence. Unlike an illness where you're not voluntarily absenting yourself, you're ill, you can't be here. If he doesn't want to be here, I'm not going to require it. I do think if he's not here for closing argument, that we'll probably still proceed in abstention, but I may well issue a warrant for his arrest.
I know we're fine.
Okay. I just want to make sure we're clear about the rules. I'm imagining that, and it's entirely possible if for whatever reason we couldn't do that to Friday, we would do it Monday morning. But let's hope that we can get more done than that. Because I think you would all like to have even the order and the numbers of even if all the instructions were agreed upon, you'd want to know what order they are and so on, because you would sometimes, as you make your preparations for your closing argument, I know if you've got especially if you've got a PowerPoint and that kind of stuff, but even if you don't, you may want to say, well, everybody please turn to instruction 41 or whatever it is. And of course the jurors will have a copy set of the instructions as we read them to them, and then of course as you make your closing argument when you may reference them. So anyway, that's what I expect the schedule's going to be. So we'll bring the jury in now. You guys can formally rest. We can talk to them about these things and excuse them till Monday morning. Right? We're on the same page about that?
Yes, Judge. Is it okay if our client Officer Rank can also just appear on Monday morning again as well.
That's fine with me too. Again, Mr. Officer Rankin, you need to understand that your presence here is, and your absence from being here tomorrow and or Friday afternoon is completely voluntary. We would expect you to be back by Monday.
Yes, sir.
And so to that extent, your presence is mandatory. We would probably still proceed without you at this point. But we may well issue a warrant for your arrest if you're not here on Monday. Letting you know.
That won't happen.
Do you want the clients to confirm that on the record, Your Honor, right now? Or?
You can, I suppose. I'm sorry, Officer Collins. You understand what I was saying about all that, Officer Collins?
Yes, Your Honor, I do.
Okay. And Officer Rankine?
Yes, Honor.
Okay. So I don't know if Officer Burbank's going to be here or not, but
I understand as well, Your Honor.
okay. So you can be here or not, you know.
In terms of resting, we're going to inform the jury that we're resting subject to admissibility of
I'll let them know.
Can we just say that when we rest? We can just say we rest.
You can.
Okay.
You can say, or you can say subject to the
Subject to the-
further orders, and I can explain it.
Thank you, Judge.
And
Okay.
then, are we going to inform the jury that closing will be on Monday?
I can. I'm going to tell them that's my expectation. Yes. You know.
Thank you,
Again,
Judge.
barring snowstorms, earthquakes, illnesses, and so on. Okay. Everybody clear about that? Great. Then let's have the jury. By the way, have you guys been working on the changes that we kind of agreed to on the instructions? Has anybody?
That was the supplemental that we filed this morning. It
Oh.
included the changes that the court can.
Okay, great. Yeah, because I know there's a number of the things that we agreed should be changed.
Yes, I believe that these amendments
Well, there's more proof, Mr. Liu, that I hadn't looked at those supplemental instructions yet. Welcome back, everyone. Good afternoon. Please be seated. Okay, ladies and gentlemen, my understanding is that the state has no additional witnesses, but there is some additional exhibits that we have to make some rulings on. But other than that, I understand the defense is going to rest at this point, subject to getting rulings on those exhibits. I want to make sure we're clear about that. So, Mr. Burtzer or Mr. Fricke, on behalf of Officer Burbank, does the defense rest?
Yes, thank you.
And Mr. Osser, and you're already nodding. Thank you. On behalf of Officer Collins, you guys are
Yes, Officer Collins rest subject to the.
okay. Subject to those rulings? Okay, thank you. And Mr. Conrad and Ms. Bremner?
Yes.
On behalf of Officer Rankin? Okay. So we'll make those rulings at some point here. Does the state have any rebuttal?
No, Your Honor, the state does not.
No rebuttal. Okay. So, ladies and gentlemen, what this means is, in the absence of, you still haven't got these exhibits, and we're going to have to identify those and make certain rulings with respect to them. We can do that without your presence, but you'll be advised before we get started again as to what those exhibits are and whether they've been admitted or not, and so on. With that exception, you reached the conclusion of the evidence portion of this trial. Now, that does not mean you can yet talk about this case, because what's going to happen is, as we talked about earlier during jury selection, that there's going to be a period where we give you some jury instructions with respect to the laws that pertain to this case. We've been working on that when you haven't been here to some extent. But we're not done with that. It's going to take a while. And then what we're going to do is we're going to hopefully get those instructions all sort of sorted out. We're then going to make copies of them. We're going to have you all back. We're going to tell you about those exhibits that come into evidence. We're going to give you the set of the court's instructions to the jury. The law requires that I read those instructions to you, and I will read them to you. We're going to give you a copy set so you can read along with me. And after that, the lawyers are going to make their closing arguments. And after all of that, the court will excuse you to go back to the jury deliberation room. At that point in time, you can take your notes with you, the court's instructions, and Mrs. Winnie will bring you the exhibits that have been admitted in evidence. And once she does that, she will also say something to you, something like, 1, 2, 3, go. She might say something just a little more formal than that, but in any event. The point is that she will tell you that you can start your deliberations. And when she does that, you can then discuss this case among yourselves. Until that time, even though we're close, there's no cigar quite yet. So that means that you should not discuss this case among yourselves with anyone else, and not permit anyone to discuss this case with you or in your presence. You should continue to avoid any reports on the subject of this trial, either in the media or social media or anywhere else you might potentially encounter them. It's going to take us a while to do all that. And so while I would ordinarily have you back here tomorrow, I'm thinking we're still going to need that time for us to do this other work. So we're going to have you back on Monday morning, and hopefully at that point in time, all of this will be ready to go. The instructions will be there. We'll just tell you about the exhibits and how those turned out. And counsel may discuss them with you, but we'll go through reading the instructions and so on. So that means that at this point in time, you're now excused, like you're excused for the day, but instead of till tomorrow, until Monday, when we expect to have closing arguments. How long they'll take, I don't know. As I say, after all of that, Mrs. Winnie will let you know when you start your deliberations. Okay? So thank you very much for your patience, and we're getting there. Thank you. Okay, please be seated, everybody.
Your Honor, before permission, Mr. Nicolao was going to argue this issue. Can I be excused?
Yes.
Thank you.
Counsel just asked if she could be excused, and I said yes.
We object.
I think they're on. Oh, then, you mean a council table? They can always try to turn them on there, yes. Okay, so have you got the defense proposed redacted instructions? Just to-
I do, Your Honor.
Okay.
The issue with it I have is, and among other things, is, this is different than what we were initially given. So the copy of redactions that the court has are based on what we were initially given, so it's a little bit confusing, so I apologize for that.
Okay.
There's quite a few pages that were removed from, Mr. Conrad's, based off of trying to narrow it down, but we weren't sure if he was gonna remove those, so we included a lot of blacked out pages in the package to try to support the state.
Okay, well, hopefully we'll still be able to do something productive. But, so now that we've got the defense records, can we at least turn to those? And then I've got these, and I've got the proposed state's version. And since I just got those, I haven't had a chance to try to compare them, which is what I'd hoped to do. But let's at least start with the first one, which is, at least that I've got from the defense proposed, new proposed one. We'll start with that since they're the proponent of this. Exhibit 2029A. And let's see, is there any,
Your Honor, the 2029 date from the state's perspective should not be in it at all. And if we actually have it in our packet, but it's further back. Excuse me, it starts with, Rankine, Summers 5, 4, 5, 6 for Bates. And the state's position is it shouldn't be admissible at all, because there's no testimony tied to it. In addition, that we do find it confusing. I understand the reason why defense wants it in, and it's regarding the recommendation for heart surgery, that there's no explanation of what that surgery is. There's no explanation of what it would entail, why it was recommended. Again, it's from back to 2017. The state, as far as redactions are concerned, the state's redactions would include the entire 3 pages of the exhibit.
Mr. Conrad, you have reduced this now to 2 pages, I think. And you've eliminated the second sentence in the first paragraph on page 2, and then the rest of it on page 2. So we only just have those, 3 or 4 sentences there. And the cover sheet, if you will. Okay, well, as Mrs. Winnie was back here now. Is she still doing with the jury? So Exhibit 2029A is now most recently redacted, I'll admit. Next one is Exhibit 981A. Ah, well, there you go. Mrs. Winnie? I don't know if you've got this version there, but what we just decided was Exhibit 2029A.
And Judge, we still need to give we were waiting on getting the admitted copies to Ms. Winnie until we made decisions today in case they were further redacted.
Okay, well, okay. So Exhibit 2929A, defendant's proposed redacted copy is going to be admitted, we do need to get those to her. By the way, there was also the exhibit, was it 17 this morning, where we're going to redact part of the CAD? Have you guys got a version of that for us, with the redacted version? This is when he's noting her, no, hasn't got that.
It's been prepared, we'll hand it up to Ms. Queen.
Great. Don't let's forget that. All right, so now we're looking at 981A. And, let's see.
Your Honor, based on the court's prior ruling, again noting our objection to, but we did leave the entry on the second page of that, with the late entry highlighted version that the defense commission wanted,
Yeah, I'm trying to find,
and redacted the remainder of that.
I'm trying to find where your version of that is.
It's the second one in. Excuse me, I think it's the first one in.
Yeah, but it's not. The first one is 2026. Then the next one is 984.
I'm looking at 981A. It starts,
I guess I'm saying is on the copy you've given me, I don't have it.
on the copy we gave you, Your Honor, it should be the second one after this new divider page. Is how we received them in electronic form from the defense.
Yeah, I guess I'm telling you, that's not what I've got here.
Wait, sorry, Judge, what's the base? So you're looking at 981.
That's 981A. And then the first one on the first page of the state's version is Rankine Medical Expert 5876. And that's simply not the same document.
Your Honor, if you want to hand it down, I'll provide it to you. The way that ours was printed up was in the version that we received it, so.
Sure, here we go.
Yeah, right here. The first page is blacked out, and the second page is the same.
Let's see. Yeah, but what confused me is it still doesn't say anywhere that it's Exhibit 981A.
On the page that's blacked out, Your Honor, it says 981. This is the version how we received it from defense, and so I have not added the A's to it. It's
Okay.
simply what we received.
Yeah, it's put on both sides, and that's why I missed it too. Anyway, so you've got their whole page one missing, and then in page two, you've got the paragraph with discharge instructions blocked out, looks like. And then I guess what is it? Is that then the next couple of pages are completely blacked out?
The run report and the discharge instructions.
Let me take a look here.
There is no testimony from the run report.
That's not true.
Sorry, this is 2019. I can barely read the run report.
Well, what's testified to? Of course.
You mean page one?
No, Your Honor,
Hey, well,
it's
so,
page 44 on the left-hand corner. Page 44 is the run report.
Well, my first one starts at page 48.
Run, R-U-N. Run report, not
why don't we stick with Rankin Medical Expert as reference instead of page?
right. to tell you, the small print there.
Oh,
I can't
okay.
necessarily read all of those numbers.
That says 3817. It is small, very, very small print, I grant you that.
Yeah, 3817 is the first page, so then it would be,
Okay.
And the state wants to redact that too, of course.
yep.
Well, the lorazepam was testified to as to when it was given and why it was given. And that it indicates when it was given, and that was testified to. That's why I want that in.
This is the Ativan
Correct.
for the September 2019 medical event. Okay, what about blacking out the paragraph on page 2?
The only reason I kept that in is because I haven't looked and said the state wanted it in, so
So you don't mind if it goes out?
I don't.
And then how about the next several pages? I think after that, the state redacts everything.
Sorry, Judge. The next page is that patient care report, that was Pierce Fire. That was testified to as well, indicating that Mr. Ellis admitted to methamphetamine use a couple hours prior to the 2019 incident. So it's obviously important information. You redacted the other information the report said was probably hearsay.
Right, that was the police information.
Police. And then we also redacted, you said that there was confusion about this, there was a date in there,
There was like a scan date or something.
and so we got rid of that.
Good. All right. The next one, up at the top where it says discharge instructions okay to book. Is that like telling the police they can book him? Is that what that is? I don't know that they need that.
Don't need that.
Well, we know he got arrested and charged at some point.
We know he was in custody as well, because that was testified to by the Pierce County prosecutor, that he was in custody from X date to the date that he was released.
Okay.
From the state's perspective down there, there wouldn't be any needs to corroborate it with the medical record.
Well, but it may tell them a little bit about a police procedure, and I'm not sure it makes any difference. Okay, well, I guess I would say that defendant's 981A can be admitted with the additional redaction that's proposed by the defense right now, with additional redaction of that second paragraph about discharge instructions that the state proposed. Do put that in. Or at least redact it out, rather. Otherwise, it can come in. And now the next one I've got is Exhibit 984A.
Now they're on the first page, the state's asking for that whole first paragraph to be redacted.
Right, some of it's out already. Let's see what we got here. Why do you want that out?
Your Honor, again, I think it's already been testified to. There's plenty of evidence that he uses methamphetamine and was using it in 2019. And again, references incarceration, that he was in custody from 9/22/19 until 10/30/19. And references his release.
Well, right, but I assume what the state really is interested, or the defense rather is really interested in here is the idea that he was abstinent at least for some significant period of time. Now, this doesn't take us right up to the date of this thing because this is in November of 2019, but it does indicate that Mr. Ellis was saying that since he was incarcerated on September 22 and through his release date and even thereafter for another couple of weeks, he had been abstinent, which is part of their point about abstinence.
Right, but when you go to the next page, it already hits the 9/22/19 date for the last year of use. So he's getting that information in.
On page 2 at the bottom,
Right, he's getting that information in without it going through the incarceration aspect of it.
it's also mentioned at DEM 4 and 5.
I mean, certain information before the jury. And there,
And even 4 and 5 have got business about being arrested.
Well, the state's asking for first 3.5 lines to be redacted.
Ah.
To start with, he reports a history of multiple treatment attempts. So that would be a portion that would be admitted, and what is before that would be redacted. And it doesn't change what defense is getting in, that they get the last use of drugs on 9/22/19, which is what they're
but the,
reporting to get.
those specific sentences, which counsel knows this, was already, that was read from the witness. So, I mean, it's in evidence.
So then why do we need it a second time?
Counsel, I'm sure you're gonna make an argument about this in closing to the jury about whether it exacerbates his mental illness or not. So,
Let's go to the
a medical record that's objective on
Let's-
this issue is important.
let's go to the next page. State proposes that the first paragraph, I guess we'll call it that, general notes, be removed.
Correct, Your Honor. Again, those dates are already provided in other areas.
And then the business about hearing voices. State also wants to redact that.
The line between other miscellaneous on the bottom
Right.
paragraph. Yes,
Just because the defense has removed the other two things, which I think I had suggested.
correct.
Okay, well, I'll accept 984A with the redactions that I previously requested the defense has provided here.
So what was the previous, the ones we've already made?
The ones you've already made, so.
Understood. Thank you.
Your Honor, what about the pages that follow?
Oh, I'm sorry, I thought that was the end of that exhibit. The state wants to black out all of that, I guess.
Well, defense has subsequently removed several pages. That exhibit was initially 4 pages and what you provided the second time, I believe.
I don't see anything problematic about the rest of this. And these are, by and large, although it's not a narrative, it's by and large from the context here that these are statements by Mr. Ellis for his medical care.
From a November 14th of 2019.
Right. And then on the summary assessment. Yeah, with those new redactions that the defense has made, I'll admit 984A. Okay, and then we got 2004A.
And Your Honor, on 2004A, it's the state's position that the entirety of it should be excluded. It's a July of 2015, the court previously reviewed it and didn't see anything that would be that would be admissible in it, or that would be relevant. There was the uncontrolled hypertension, I know defense works that in, that wasn't tied to, I recognize he said the other day, look, we asked that line of questioning, but in my review of the records, and I could be wrong, but my review of the records, this document, this exhibit was not shown to any of the witnesses.
2004A, you may be right about that. Yeah, I'm not seeing any note where it was asked.
Say it again, Jeff.
I'm not seeing any note in my records or my notes of the case where Exhibit 2004 was brought to the attention of any healthcare provider, or anyone for that matter.
Well, the uncontrolled hypertension was something that was testified to both by the state experts as well as Dr. Stenhead.
Yeah.
Initiated, and now you have a record indicating that there's a doctor even dating back in 2015 has concerns about his uncontrolled hypertension.
Yeah, well, that's a diagnosis. So I'm going to not admit Exhibit 2004A.
Your Honor, sorry to interrupt real quick. It's
Yep.
okay if Officer Collins, maybe the other officers are excused at this time.
Well, this is an evidence-taking portion of this. If they want to voluntarily absent themselves, they can.
Thank you.
Also, Officer Rankine would like to be excused, Your Honor.
Okay, if they want to leave, that's fine. If they want to come back, they can come back. All right, so 2004 is out.
2004, not 2008.
2004A. I was hoping you'd leave.
Can I do voluntarily after myself?
Yes, you can. You can.
Thank you, Your Honor.
Your Honor, at the end, can we go through this just to make sure I got everything right?
Well, try to, but try to stamp with us.
Can I ask what the rule, so you're saying that the 2004A is not admissible, is that right?
It's not admitted.
Is that because it doesn't bear any, there's no relevance to it?
Because it seems to me the only thing you want in is the conclusion of a doctor who's never testified. It's one thing to have the reporting of the patient, but now we've got a medical conclusion without any understanding or support of it. So that, plus it's also 2015, you know, I mean, at some point it becomes attenuated. So to me, it's of little relevance and or it's admissible as hearsay.
There are quotes, okay, understood. No, I understand that portion of the court ruling. There are some quotes directly from Mr. Ellis in there about the negative voices.
Yeah, but that's already in the records. Now, yeah, I won't bore you with my theory of cumulative evidence, but, which I've already bored you with before.
No, I
Okay, so now we're at, I guess we're at exhibit,
2005.
yeah. But I'm trying to find where the state's 2005 starts.
You'll see at the bottom of the first page, it's just it's a blacked out full front page. And it follows the 2004 on
I'm just not seeing a
it. Okay.
2005 anymore.
I can,
Yeah, I don't see anything until I get to 2006. But you want the whole thing out anyway, so it doesn't matter, right?
We do, Your Honor, but if the court's gonna allow part of it, then there are portions that we would like, but if you wanna, hand it down to me, I can,
Well, there's nothing to track because it's all black.
there's a spot where it's,
Really? Okay,
right there.
this is 2000,
If you look down at the bottom,
is this 2000, oh, there's 2000, well, wait a minute. Maybe I've got this. Okay, yeah, I guess I do. On the second page and the third page,
If the court's, again, from the state's perspective,
the second and the third page, and that's it though, right? Just those 2 pages? Is there anything in there that you want?
well, Your Honor, from the state's perspective, there's not anything in it that should be admissible because there's no testimony from it, in addition to the fact that particularly, I believe, based on prior highlights from the defense, what they want in is the third page in paragraph of under HBI, and it's not tied to anything, it's not tied to any, expert testimony at all.
But the objection that was gonna be made was the relevance, and that was it. And now I'm hearing new objections being made as to, oh, no one testified to it. And well, first of all, I don't think that's true. I went through a summary with Dr. Stankus on the relevance of the records and what she found in there and what she found particularly relevant in there. But the sole objection that the state was making during this process, which again I've made my position that I think that they waived that under the RCW plainly, but that's the relevant zone. And I'm hearing new objections being made. I don't think that that's fair, and it's not pursuant to our stipulation.
Your Honor, the state said that the records are not, we're not objecting to them as far as authenticity is concerned. In addition to that, the reason why it wouldn't be relevant is because there's no, testimony tied to it. And I went through Dr. Stankus because I thought she would be the one that would have testified to it, and specifically looked for 2015 instance, and I may have missed it, but I did not see anything from her on it, on the 2015 time period here, so that's the basis for objecting to the HPI. If the court is going to allow that section in, then the state would ask, that the following pages, looks like defense did leave in the following pages on this one. As far as the physical exam, which is what we would ask would stay in, we would ask that the pertinent labs, section and that what follows be redacted, and the reason for that is, one, it's confusing because there's no testimony tied to it, and it's not relevant to what's before the jury in this case. Further, when you're looking at the UA screening, these aren't done as a drug test. And as the court knows, the reliability of UA screening is limited and is not admissible for the purposes of criminal trial, not talking about probation violations, things of that nature, but as far as criminal trial, UA does not have the same accuracy level as a drug test. So this was
Again, these are different objections that are being made than what we stipulated to the fact on the record. And I specifically had Ms. Eaps.
Well, if it's an exception, if it's an objection that would, well, I hear you, but I'm going to consider
Sure. Well,
the state's objection.
there is a statement from the patient in this record that says, patient does state that he has AH, which is auditory hallucinations, and it's abbreviated early on. They are praising me. Patient states that AH are not bothersome, but they do increase when he uses meth. It's at 520. It also indicates all the additional times that he's been going to the emergency department. 4 visits to St. Joseph Medical Center, 7 visits total that they count up. Which again, we don't have records from all of those different visits, so we don't know what's really going on with him during all this time period.
Why do you need the last 2 pages at all? Just, these are just properties items that were taken by the hospital and
I think I
returned.
just missed that, Judge, so I can remove that.
Well, those should go out. But I'll let you have the rest of it. So, subject to those 2 pages being removed, we'll admit 2005A. 2006A.
Robert, why would this history of suicide attempts,
I think he,
I mean,
I think for one thing, he denied suicidal ideation, right?
why
Wouldn't that help your case?
It's not relevant to our case.
Well,
There's nothing that,
it's part of, it's my understanding how doctors make diagnoses, they do what they call a differential diagnosis. And what they do is they take all these symptoms that I've got, and those collections of symptoms may point to 2 or 3 different directions. And sometimes what they decide to do with it depends on what is eliminated. And so eliminating suicidal ideation is, for instance, a reason for, drug use might be an explanation that would require a certain kind of care and not others, for instance. It's all part and parcel of the whole clinical picture at that point in time.
I would just note that when defense initially provided what they wanted out of this document to the state, and what they said on the record to the court is they had highlighted portions of what they wanted to get,
Well, what they really wanted to get, I think, is the way he put it, but yes, go ahead.
which was 1 paragraph out of this entire thing, and it's that highlighted portion under HPI, and now the court is taking a position that, we're gonna put all of this in because they've changed their mind on it. I mean,
Well, now you're complaining that he's changed his mind about the ground rules here, and he's saying you've changed your mind about the ground rules.
I didn't change my mind.
I'm not going to argue about it anymore. That's my ruling. Now we go to 2006A.
Your Honor, I would note that the 2006A that was initially sent to the state was about 100 pages, so about 80, I think. So it started on page 53 and from the medical record pages. And from the state's perspective, almost all of it is irrelevant. There's several blank pages in there that say no provider notes, nothing of relevance.
And I removed those, and then state just put a big black box instead. So we went about things in a different fashion.
Well, I think I told you to remove a bunch of that stuff. That was
I
just
was listening.
empty pages. Yeah. So it's now about 6 or 8 pages, I guess.
So from the state's perspective.
Maybe 10.
Page 61, which is the first page of the newly offered one to be redacted.
Well, essentially you're saying I should remove it,
Yeah, it should be removed.
except for identifying who it is. Let's see.
I don't really see that as, I mean, I would probably.
I think he's removed the first page. His starts at
It starts at
2411, 2411, and yours starts at 2403.
Yep, so if you go to 2411, which is also 61 of the document itself, the state's position is that the first 3 pages of the subsequent one should be removed as not relevant. If you get into the ED progress note, which I think is what you really want to see.
All right, so all the previous stuff. You didn't blank out the very first page, but he didn't include that as his proposed. But the only thing that's on there is it's Mr. Ellis's name. So now we're at 26. So he takes out those first several pages already. hold on, hold on, hold on, hold on, hold on, hold on. All right, so I'm looking at page 2411, I guess it is, or page 61, what do we want to, the first part of 206A, 2006A. Right, so, Mr. Conrad, what do you want about this, except it suggests that Mr. Ellis was surly with mental health, or the people at the hospital?
He leaves against medical advice.
Yeah. Well, what does that tell us about his encounter with the police officers that night? Not much of anything, I don't think.
Well, it tells us about his medical status and whether he's getting appropriate care over the years, because he has a number of issues that come up. He doesn't go and follow up with, he doesn't stay in the emergency department when they ask him to stay and get treated. And so his health declines over time.
Well, I think. In the prior exhibit, it talks about where he was seen for drug problems and then he eloped. That sort of says the same thing, doesn't it? I mean, slightly different circumstances, I'll grant you. But it's the same point.
I would agree with that.
All right, so then we've got, I'm looking now at your page, 104, your page 2454. This mentions a business about the wound to his foot.
I thought we removed that.
Well, it's on
Oh,
the description of his course in the emergency department.
It's also in the impression.
Yep.
And the leaving without, against medical advice, they actually discharge him on the next page. And say, I don't believe he needs permission at this time.
The only thing I see that's really potentially pertinent here is his, first of all, at least the chief complaint, hypoglycemia, which is interesting. And then it says, found wandering into a school, confused, patient vague, not talking at times. Which the not talking thing matters at least a little bit here because of this business about whether he's responsive or not responsive. It's mentioned again later on that he presented ranting about Allenmore, was combative while being transported. In the emergency room, he only said, I need detox, and refused to answer any other questions. And the only reason why that matters much, I suppose, is that he doesn't like to talk to authority, it seems. And then they ultimately said with prompting, they were able to find out some other things. But the wound on the foot stuff, I don't know that you need. So, where it says last seen at Allenmore Hospital with, and then there's a blank, a redaction, which is, I gather there was probably the business about the wound on the foot then, I don't know.
It said gunshot wound, so I thought we had removed that.
Right, so take the word without as well, that's right in front of that.
Yes, sir.
Your Honor, again, there's absolutely no testimony tying this to anything that's relevant on this case. I mean, you're saying.
Hold on, let me finish talking. Then that whole last sentence should go out. The impression too about the wound on his foot should go out. Now, what did you want to say, Ms.?
Your Honor, there's no evidence of this being unresponsive. He stays there, he talks with them after he's not saying, I can't breathe, he's not, and as the, Lieutenant Wilson testified in the state of a rock, I mean, basically comatose. I mean, he's choosing not to respond at points, and then he responds and interacts at other points. He doesn't have a 1,000-yard stare. It's not as if he's incoherent during this one. There's been no testimony about hypoglycemia and any impact about that on for cause of death from anyone. I mean, it's misleading, confusing, and it's not tethered to anything from the case.
Here's another quote, Judge, as well, as why I wanted this in. It's at the Bates 2464. And he says, the patient stated that he's become paranoid in the past, but only went on that. He hasn't used in 2 days.
And also,
When police questioned, he asked, it talks about when police questioned him, when he went to Pierce County Alliance and acted deaf and retarded,
active.
and that he thought he was being followed like an invasion of cops.
I would also note, Your Honor, that the defense has conveniently removed page 106, excuse me, 108, which previously talked about, oh, this here, the assessment is methamphetamine abuse with toxicity, which is now resolved. Doesn't want to have that in, so removes that page,
Well, you can put it back in, I don't think they'd complain.
It's in there.
it's not on the most recent one. The most recently submitted one does not have it.
Mine goes from 105 to 10.
Again,
Mine goes
again,
from,
missing it.
mine goes from 105 to 108. So I agree with Nicolova. I don't see it.
On 108,
Is it-
but she's saying 108. It's on 108.
No, she's saying it's on 107, I think.
Not 107, the portion that he has on 108 will include the methamphetamine toxicity. Still think that all of it.
He's left that in,
He's left in the methamphetamine toxicity on 108. It does repeat it there.
which is now resolved, which is what you said he should leave in.
Still think that the entire issue that the court has brought out is not relevant to this. In addition to, he's got gunshot wounds in his extremities. I mean, again, it keeps going through law enforcement was called. EMT was there for an incident that has not been testified to about at all.
Okay, there's also on page 105, 2455 on the Bates stamp. Gunshot wound was addressed by Dr. Pace. That should go out.
Where is that, Judge? I missed it.
Year 105 or year 2455, whichever one you want to use.
And you're on 105 again talks about suicidal ideation.
Up at the top, it says gunshot wound was addressed by Dr. Pace. That should go out. It does.
And there's been no testimony tying suicidal ideation to anything before the jury. And again,
Okay. So, take that that sentence out at page 105.
Is the court indicating to take the statement out about suicidal ideation or take?
No. All right, so take that out at 105. Take the couple of things we talked about on 104.
Judge, I see another reference to the gunshot wound on 108, emergency department courts. It says, I reviewed his record from Allenmore a few days ago where he's seen for a gunshot wound and left against medical advice. Do you want me to take that out?
Yes.
Your Honor, is the court gonna have them take out the top paragraph there after general? I mean,
No.
it's again, a law enforcement contact that hasn't been testified to that. We'll have to follow up on this foot, the bottom.
Okay, all the stuff before 104, the 61, 79, 92, that's all out. So it starts at 104. 104 make the redactions we talked about. 105 make the redactions we talked about. 108 make the redactions we just talked about, plus the ones that are already there. And with those changes, this exhibit will be admitted.
The judge on 114 is the sentence that I just talked about where he says that he becomes paranoid in the past with only one non-match and hasn't been completed.
Yeah, what about it?
So I think that's particularly relevant to this case.
Well, I didn't say it was out, did I?
Oh, sorry. You said all the pages afterwards, right?
No.
Sorry.
All the rest of the pages after that are in. It's all the pages before 104 that are out.
Oh, agreed.
Okay. Now we're at 2016A. Two 2016A was admitted? No, I'm just saying we're now at that point. We're going to talk about it.
That's,
2016A was admitted? One before that, 2006A is admitted with the redactions we just talked about.
that's what I was asking about.
Right. Now we're at 2016A, and again, I'm trying to find it on the state's copy.
It's like the defense page, so. Those pages. It has Mr. Conrad's highlighting on it.
Was there, did you object to the entire exhibit?
Your Honor, it's the first page, as Mr. Conrad has it. Left it. That's it. I mean, we've objected to
Well, I'm just trying to find page 1 of your redactions, and I'm not finding it yet.
It looks just like his, but it has his yellow highlighting on it. Our version has his highlights.
I thought I was looking at that already.
Sorry, Judge, I don't know why, but I don't think we printed this in the same order, so sorry to make this a bit more complicated.
It's not the same order as yours.
I just said that.
Yeah, and I appreciate that clarification.
Thanks for saying it to me.
Well, I think I'm going to ask Ms. Nicolavo to come here and find the page that she's got on this.
Judge, while you're waiting, 2016 was testified to. Specifically, the portion that I left unredacted.
Oh, okay. Well, that was way after where I was looking. All right. Could be. It looks like you guys are basically in agreement as to the first page. Am I missing something?
Based on the court's prior notations, we were in agreement with the
Okay.
We object to the second page as it doesn't give any context to the quote, I could die, I almost died twice. There's no context to it to tether it to anything. And the heart condition, or ongoing heart condition has been testified to multiple times in addition to being noted in numerous records.
But I had the witness specifically read these portions of this exhibit. Obviously, this is an issue that's highly pertinent. There was no objection at the time that it was read.
All right. So this business, I could die, I almost died twice, in response to a question about his medical history, is what, bearing on what?
Say it again, Judge.
The statement, I could die, I almost died twice, when he was asked about his medical history as it impacts his current functioning.
Yeah. So he says that in July of 2019.
Yeah, no, I understand.
A couple of months prior to this incident, he's indicated that he has an ongoing physical
heart condition.
It was read from by the way.
Well, maybe I've got, it was mentioned a couple of times. That is Exhibit 2016. I don't know that this was referenced particularly. I got a reference to page 572, or 5872 rather, and 5941 and 5923. Well, that's a different exhibit, sorry, but 5872. But not 5867. Now, maybe I missed it. Could happen.
I know it was in here a couple different times, so maybe that was. I know that I specifically had Miss Pastelares, Rochelle, read from that portion.
This was during her testimony, all right.
So, I can pull it up as well.
All right, here we go. I have a note that says, ongoing physical health concerns, heart condition, semicolon, I could die, comma, I almost died twice. I don't have the page number, but that's my note, so it must have been read.
Again, Your Honor, it's not tied to anything. He could have almost died twice in a car accident. He could have almost died twice in, getting beat up by the cops. He could have almost died twice in a different altercation. There's
Maybe.
no context to it.
Maybe, but this was asked of Ms. Pasteras.
Well, the defendant's statements are questions that were asked and admitted, and the court's not admitting the exhibit for their transcripts. For the jurors to go through the transcripts. I mean, you're not reproducing transcripts of everything that's been testified to.
Thankfully. I'm not sure how that pertains to this. Okay, so. What about 5874? Do we need this page at all?
Do we need it out or in? I'm sorry, Your Honor, I didn't hear.
I'm saying, do we need it at all? If we don't need it, we should take it out. And the same with the next page.
No, I think we can probably take it out.
Okay. I'll accept the defense proposed 2016A minus the last two pages. Okay, the next one is 2019A.
Your Honor, in your packet from the state, I believe that follows the one that we just went through.
I'm sorry? Could you say that again?
I believe that follows the one that we just went through in your packet from the state. You're looking for it.
So it's the very next one? Okay.
This is, like, even though I pointed out to the defense when we discussed this one, that page 879, the state had a section that we wanted in, that was in what was initially provided to us. And Mr. Conrad, correct me if I'm wrong, but is 879 been removed from your now terms? The quote from Mr. Ellis saying, his safety plan is being around my sister helped. She made me sign a contract stating that I wouldn't do anything stupid. I like to drown out those voices with TV and talking to my daughter, which I believe is consistent with what she, or what she testified to. And it appears in quotes, so one would anticipate that it would be directly from Mr. Ellis.
I don't believe that's part of the proposed redacted version, if that's your question.
It was in the initial set that we received from
Yeah,
the defense.
okay.
And so the state would ask that that be added, Your Honor.
I can't find your deal again, I have to tell you. I mean, all the pages look the same, right?
Yeah, well, that's what happened with it.
I mean, this goes on for pages like this. And
That's because we took what we were initially given. I didn't want to modify it without.
so 2019A, if you can find that.
Here we go.
Thank you.
That's the section that I'm talking about. 2 pages before that is the beginning of it.
So this is what they want in.
Looks like a discovery.
Well, okay. Oh, I see. And part of the deal is it's because it's printed on 2 pages on one side and not the other.
I know, I'm not a person that likes that at all, Your Honor.
I appreciate saving paper. I'm all for that. Okay.
They don't even like us to print things.
I mean, what's the, I guess, what's the relevance to what the state is offering?
So hold on a second. There's no dispute about 1, page 1.
Court's letting it-
Page 2, there's a dispute. You want to indicate that he's taking these antipsychotics, right? Okay. Page 3 is missing now. This is page 879. That's not in the defense proposed version. So why not have 879 in?
What is talking to his sister and listening to TV? Or talking to his daughter and listening to TV? Have anything to do with this case?
Well, certainly the information in these other medical exhibits talk about Mr. Ellis's attempts, failed, sadly, to get drug treatment and so on. So, some of them early on indicate that he hasn't had any, but then he then says, I need to go to detox and I need to get into treatment and that kind of stuff. I was actually not sure why the state would want this in part. I mean, it makes Mr. Ellis look like a sympathetic guy. There's no question about that, and there's nothing wrong with that. But the fact of the matter is that when this happened, he was no longer around his sister. So to me, it some actually helps the defense to say the things that were helping him in his life that he talked about, being around his sister and so on. But that was helpful, that she made him sign a contract that he wouldn't do anything stupid, whatever that means. watching television with them, talking to her daughter to help drown out the auditory hallucinations. He didn't have that in his life anymore at the time this happened. So I see this potentially helping the defense. I don't care much one way or the other. As I say, I'm a little surprised the state wants it in, but
He did have those things in his life. He talked to his daughter that night.
well, maybe, but he was no longer living with his sister. He'd been removed from the house.
Well, being around my sister helps.
Right, she wasn't there.
She's still having contact.
I'm not going to argue the point. I'm just saying that there's reason to think this could be actually harmful to the state's position here and helpful to the defense. Maybe it cuts the other way too. It could be. As I say, it puts Mr. Ellis in a sympathetic light in the sense that I have this overwhelming sense that Mr. Ellis was the victim of his mental health problems. And the sad part for him is that you can't solve your mental health problems if you're intoxicated. But when you have certain kinds of mental health problems, like schizophrenia, getting sober isn't going to solve your problem either. Sadly, you're going to have a problem either way. And that's just really tragic that some people walk through life with that. It just is. And so Mr. Ellis was in some sense in a box, not of his own creation. But nevertheless there, trying to get out, and there was no way out. Just a real sad deal, I think. Anyway, if the state wants it in, I'll put it in. The next page that the defense is proposing, it's hard to tell what the number is because it's been worked over here. Bless you. And the state wants the whole thing out, I guess.
State's position that it should be excluded. I know that he previously wanted, we stand in objection all across the way, Your Honor, but I think that first paragraph on 880 is consistent with what the court previously said she didn't find this.
Yeah, I'm just going to say, he talks about his last use, September 22, 2019. Besides that, what do you want that's on here? Because that's in the records elsewhere. What else do we want on this page? Because I'm not seeing much.
Maybe it's not going to chemical defense treatment.
Yeah, I think he says that elsewhere too. Although he was supposed to be getting into it at this point, right? I don't know. Do you really want this?
I don't have a strong feeling about this one, Judge.
Okay.
That page, I should say.
I get it. I'm not sure what page that is, 880, it's before 886, I just can't, it's been typed over, so I can't read it.
Yeah.
It looks like it's 5951
Yeah, that's what I see. So you want me to take that out?
out.
And in terms of the state's page that they want in, the 5949, do you want us to redact it the way the state has, just so that one sentence remains in there?
Well, that's the only thing I know that anybody wants. So, yeah, I guess. Okay. Next page, 5956. Is in 5957. Do you need any of this?
I mean, there's co-occurring mental health issues with substance abuse.
Right, but that's isn't that everywhere in this thing? So on the page before it that I let in, client qualifies for diagnosis of schizoaffective disorder, depressive type, et cetera, amphetamine type substance use disorder, cannabis use disorder. How many times do we have to say it? I think 5957's out.
Okay.
What's the need for 5958?
It's risk of deterioration.
All right, well, 5958's out too. So those are the last couple of pages of that exhibit. Which was 2019A. Okay. 2026A.
Might be in the very beginning of the state section.
Might be at the very beginning. Okay. I think I remember that maybe being at the very beginning. Yeah, let's see. Yes, 2026. Okay, thank you.
I think the whole section on the legal system should be excluded. The bail amount, the Rob 2's already been testified to, is in numerous other places.
Right.
The assault charges or sexual offenses.
Hold on a second. So, Mr. Conrad, why not take out the whole middle paragraph there like the state is proposing? I mean, it's kind of elsewhere in these reports again, too.
Well, it's testified to. Oh, I don't know why it denies assault charges and sexual offenses. That should be out.
Right.
But the per Pierce County Wings manual.
I don't remember, I'm not sure if the amount of bail was testified to, for instance. And I'm not sure it matters. Mr. Greer might have testified to some of that, I can't remember.
Not the good one. No, I think that, again, Rochelle Pasteris testified to that sentence.
Well, I think it's not been disputed that he was charged with a felony, and it went all over the place for what that felony was, so it's been in the record numerous times.
Yeah, but the thing about this one was to show that basically they had failed to get treatment, right? It was another discharge summary.
Correct.
He failed to come in. I mean, I don't know. I agree with the state to take out that paragraph. What about the next paragraph or the next state redaction, which is the bottom 3 sections? Why do we need any of that? Some of it's blank, for one thing. So I agree with the state as to this page.
That sentence was testified to, but just so you know.
Which sentence? About his bail?
I believe so.
I don't know. I'm not sure it much matters. She mostly talked about the fact that it was a no-show.
You're right. I think that's She did testify to it, but I understand the court.
Right, and it identifies its discharge summary, so. Again, I agree with the state's changes there. Looks like the state agrees with part of the next page.
Based on the court's prior notations, yes, the one section that we have redacted is the legal issues resulting from substance use probation violations. Probation violations, there's legal issues. Not relevant, there's already been substantial testimony about legal issues. It's not relevant to medical treatment.
And this is a date of service of August 2019. This isn't like in November or whatever, right? After the September charge for the A&W. So I agree with the state. We should take that out. Looks like the next redaction's agreed to. Then the final redaction. I think there's very little here that matters, I suppose. Client did not see the Greater Lakes medical provider. Box is checked, and that's redacted out. I don't know why the state wants that out. Well, I think with respect to this page, the defense proposal's fine.
Excuse me, Robert? What page are you on? 807?
807.
But I thought you just said that the state's redactions regarding probation
well,
violations, et cetera, should.
You know, that's right. I mean, with that one exception, the rest of it we'll leave. So that in the prior page. Now we got another page. I guess the state wants the entire thing out.
Your Honor, again, there is a testimony as to what risk issues means. And there's several boxes here that are checked off without full explanation. And
So the state doesn't want that in because it shows he's not in compliance and not going to mental health treatment right around the time of this incident. And this was specifically testified to by the witness.
risk issues remain but not imminent. Crisis safety
I don't think
plan in
that's
place.
fine.
I
Maybe
mean,
redact that.
and the schizoaffective disorder, depressive type, PTSD, all of that's already been testified to and is in so many different places throughout this. And it's certainly not accurate that he can't live independently without support. I mean, he was a functioning adult that was living in a rehab house but could live independently without support. It's not accurate and it's not tied to anything.
Well, I'm not sure I don't know whether it's accurate or not. It certainly might be something in dispute. But it seems to me that on the prior redaction, I took that out. So I don't see a reason to put it back in. The only, so I guess I would, as far as the risk issues remain but are not imminent, you can leave it in or take it out, I don't care. The other redaction, of course, is agreed to. As for that section that says GAF, CGAS on admit, et cetera, and the little check boxes about inability to live, whether it's true or not, I don't know, but I struck it earlier. Don't know that makes a whole lot of significance here, because at this point, it's something they're putting in because they discharged him because they lost contact with him, and also provides the date of that, which when they did that was December 23rd, 2019. So that's the only significance of it. So I would say take that paragraph out. The rest of it's,
Your Honor, in 853 that follows.
the rest of it can be there, but that one paragraph is out.
Sorry to interrupt, Your Honor, I thought you were done.
Go ahead.
On 853, the page that follows, Now, with our standing objection, we leave it with the redactions and defense is noted.
I'm sorry, your standing objection with what?
With our standing objection, we leave it as defense has noted. They have the redactions on the top paragraph, it's fine.
Okay, so you have no, after all, you have no objection to 853,
Well,
other than your standing
yes,
objection?
yes.
Okay, so 853 can be okay. 868 shows the efforts they made to contact him, and he was a no-show on December 16th. Hence the discharge summary. And also on December 9th, and on December 2nd, that can all stay in. As to, let's see here. Okay, then it jumps to 871. It looks like the state's got that whole thing blocked out.
This was the record that was testified to by Ms. Larry Rochelle again, where she specifically read from it. And he said, and she indicated that he appeared.
About the only thing it says on here is he appeared anxious.
On 871,
Yeah,
he appeared ill and had labored breathing, and that's 3 months prior to this incident.
hold on a second. That's not,
872.
871.
It says the same thing on 872.
yeah, 872 says that. 871 doesn't say it. At least I'm
Got
not.
a box that,
It does under other, he was in the middle of the page.
Appeared to be ill and had labored breathing. Okay. I don't see that as too big a deal. 872 is, I suppose, more significant.
Your Honor, based on the court's prior comments, I'd see 872 with the defendant's reaction, this is going to be admissible.
I'm sorry, based on my prior ruling, what?
872 with the proposed redactions by defendants is going to be admissible.
So you're fine with those redactions, except for your standing concern. Okay. So the part where he says, "I finally contacted an attorney," that's good with you? Okay. So that's fine too. So it looks like all the redactions are on page 852 and page 807 and 806 as to 2026A. Okay. Now, which one is this? This one doesn't have a number on it. What's the next one?
228A.
2028A? 2028?
Correct. 2028.
Okay, sure.
Sorry, 2028.
Right.
And this actually,
For the state's got 2027 and 2029. But I don't see a 2027
I don't.
for this, for
I
the,
see it, I've got a 2027.
yeah. You do.
I don't.
if it's, yeah, I think we forgot on the page separating them, so it's right behind 2027. Let me see if I can find it.
Okay, I got you. Thank you.
Okay, I think,
So if you look at the state's 2027, it's
Well.
the page behind it. It's
And
at
Your Honor,
the end
we
of their
agreed to
packet.
the standing objection, we agreed to the first page. If the court wants me to take a look, I'll locate it for you.
well, I saw it once. All right, I give up. I'll let you do it for me. I know when I'm licked.
So, this is, we're proposing no to all of 2027, and right behind 2027, because there's no blue sheet between,
Okay.
is the one that.
Okay, and this says 2028, so there we are. And there's no objections to page one,
Correct.
except for the standing objection, I get it. And then page two,
The state's asking for, that my father died at 32 due to heart condition.
yeah,
Be redacted, as, again, that's not tied to anything. We have no idea what type of heart condition, we don't have any testimony about his father's. Well, clearly I must be wrong because I see defense counsel laughing about that comment, so, but I'm not aware of any testimony about his father's cause of death and the details surrounding it.
And that he has family and ongoing history of family heart conditions, and that's why he's discussing with the medical provider his concerns related to his health not improving, that he's feeling weak, he's having difficulty breathing. He expressed genuine uncertainty and fear regarding his health and his future, and then relays that his father had died of a heart condition at 32.
right.
And then lo and behold, we have him at 33 years old with a enlarged heart.
So that's your expert medical opinion that as a result of
I think
those,
my Dr. Stankus is able to say he was gonna die that night no matter what.
I don't know, this might have even come up during the trial, but I don't see the relevance of it. These are not armchair physicians. One of them's a real physician, but,
Your Honor, the state is asking that the.
so I would say that should go out. Now, the state wants the next the state wants the next paragraph in.
Well, that he applies to Bates Technical College in Tacoma. What's the relevance of that?
Well, it looks like he's looking towards his future because he's not gonna die today and not gonna die tomorrow, so he's planning towards his future. And he's trying to work towards his future with his drug treatment and proceeding with the lifestyle, changing and addressing the challenges before him.
That he's
And he's willing to take a UA. I mean, you one all over the place that he's not going to treatment, but in this one, he's willing to go take a UA. He's spending time with his treatment provider. He's not resistant to authorities of treatment care providers.
We're talking about 3 years prior to this incident, and we're talking about whether he's taken a UA 3 years prior.
Well, you won in 2015 that he wasn't cooperating with the nurses.
But to me, him applying to register for college at Bates Technical College in 2017
Shows he's a human and has looking towards the future.
You know, Judge, I spent the first half of my career as a public defender defending against the prosecution for people just like Mr. Ellis, who have mental health issues and drug addiction issues, and I wish at that point that the prosecutor had been as sympathetic to my clients at that point as they are in this position. Now I find it a bit ironic that we're on this thing right now.
Was Miss Nicolavo the prosecutor?
She definitely was not. I'm sure she didn't treat them that way when she was on the other side.
All right, well,
Actually, Mr. Conrad, I spent a lot of time with people with mental health, including one that had 3 cops that he held a gun to and had 3 firearm enhancements. And based on his mental health treatment, I worked out a resolution for him to not go to prison, drop the firearm enhancements, and did an exceptional upwards for community custody to make sure he got the mental health treatment he needed.
all right, well, I'm glad of that. So at least with respect to this is about the father died at 32, that goes out. As for the next paragraph, or 2 paragraphs technically, you know, this, in some senses, this might have more significance to me if this was in September of 2019, but you know, it's February of 2017. And as far as I know, none of these things happened for him. In a way, it actually shows that all the times he was trying to do something different, and he talks about this multiple times, it does show up here, that none of those things ever worked out. And it all makes me feel all the more worse for the guy. But I don't know that it has anything to do with our case. So I'll accept the defense proposed, I guess it's 5451, but with that one sentence out at the end. And then I've got 2013A. And you're probably going to have to help me find this one again, too.
Right before 2016.
Okay.
Just for context, Judge, this was a record that was specifically testified to by Dr. Singh.
About his being treated and being seen in the emergency room in February of 2017 for chest pain.
Correct.
Your Honor, the state has agreed to, for purposes of the records of that paragraph, which is the chief complaint that he had, the portions that we redacted, we find to be confusing and not thoroughly explained for, the jurors, things like, rainbow with green on ice drawn and sent to lab, temperature 102.8 oral, and it usually don't, things of that nature just don't provide any information to assist the jurors.
The temperature?
Rainbow with green on ice,
Where are you seeing that? Rainbow.
on page 999, it's the third page in.
This is 992 we're looking at.
In 992, we agreed to that first portion of the chief complaint.
Right, what about the part above that, where it says chief complaint, you've agreed to that, just below that, and then what about above that? Anything wrong with keeping that in?
I don't know if we have the recently admitted TG records in.
Okay, because I tend to agree with you about the chart review business. I mean, that's kind of a hearsay on hearsay issue. So the redaction that you want to make there about chart review, I agree with that. The rest of it, I think, can come in on this page.
Well, the court doesn't find it relevant that was admitted to the hospital.
I didn't say relevant, did I?
Okay.
I said it's hearsay on hearsay. It's a conclusion by another deal based on a chart note. We don't even know that this provider looked at the computed tomography scan and or the x-ray. Just says he underwent those and shows a conclusion. So I think that goes out. The next page is labs were ordered. Nobody argues about that. And then we get down to medications.
Judge, can I ask one question? Sorry. If we get rid of that last sentence then, the review of the patient's past medical records indicate that he was seen in the emergency department on 2/15 for chest pain and stayed in the hospital until 2/19. Those are just, those aren't, I wouldn't consider that hearsay because it's a, I mean, it would fall under a business record exception if it was hearsay, because it's just a statement of fact as to when he was admitted, what he was admitted for, and the period of time.
Okay, I've made my ruling. Up above it says, patient reports ongoing issues with CP, chest pain. So, I mean, it's not like it's brand new on this occasion. And that he's currently taking antibiotics for endocarditis, which we've already had testimony about from other experts about what endocarditis is. So, and that would cause chest pain. We already learned all that. So that's based on his comment at the time. So take that one thing out. Next page, medications given, you want those out? I suppose what you really want is the last paragraph there.
Right.
Which again, Your Honor, isn't tied to anything. This is from 2017. Clearly it wasn't sudden death. I mean, there's nothing life-threatening about where he's at in 2017. It's a paragraph that doesn't have context to it. And they discharge him, so I don't really know how it's...
Is this associated with the gunshot wound?
No good.
Well, the reason why I ask is it says meets sepsis criteria. And sepsis is an infection. And when you have a septic infection, that is a life-threatening, deteriorating condition. But it's got nothing to do with our case here.
Yeah. He had pneumonia at the time, Your Honor.
I saw that. So that would be transitory. I don't see the need for that. If you want to, I would accept the state's redactions on this.
And I would just remove this whole page.
You mind removing the whole page? State?
No, Your Honor.
Okay, that'll be out then. Next page is 999.
Actually, I apologize, Your Honor. The top part where it indicates that he has
Right?
the indication of pneumonia, which is part of the reason for the pericarditis, which is what Dr. Stankus was testifying about.
So you want that in.
The quote regarding the pneumonia, yes,
So in other words, you want the redactions that you proposed.
yes.
Well, if you want it, I'll put it in. As to this page. Okay, next page is 999. Jennifer, do you need a break? You okay? Okay, I think the state has just the first couple of lines on it.
Your Honor, that's what defense told us they wanted in, so we thought based on the court's prior notations, you would let that in.
Okay, do you see the state's proposed redaction here, Mr. Conrad? Do you see the state's proposed redaction? Any objection to that? As compared with yours?
I mean, I think it's important that what the plan is, I think it's important, which is he's going to be admitted to the medical surgery.
What?
So I don't have any issue with the ED nursing notes being redacted,
Yeah?
but I think everything above that should be okay.
Admit to med-surg bed with Taylor under Dr. Bradford's care. I'm not sure how the court reporter's going to get this done. Admit to med-surg, M-E-D, capital S-U-R-G, one word, bed with Tela, T-E-L-E, under Dr. Bradford's care. And then it talks about calcitonin, rather, blood cultures, repeat lactate pending. What's the point of any of that? I don't even know what most of that means. This is what you desperately want in this pile of stuff that we've got for this jury?
Give or tack it.
All right, so we're going to use state's redaction on this. Although I admit I was intrigued by the fact that the rainbow with green on ice drawn, and I have no idea what that means,
Right.
is part of what we're redacting. And then I think that's the end of that exhibit. And the next defense one, and I think the last one is 2027.
Your Honor, the state's asking that be not
Given it-
excluded in whole.
This is from January 2016. From a mental health evaluation, I guess, status report. Go ahead.
Correct. Obviously, it ties again the issue
State doesn't want this in, right?
Correct, Your Honor.
I agree. Out. So 2027 is not amended. I think that is all the proposed exhibits from the defense. Is there any, one of this collection of exhibits that the state wants that we haven't talked about?
You went through all of them, Your Honor, no.
Okay, good. We covered them all. Great. All right, so it's now 3:35. So the plan is to see you guys tomorrow morning. Are you guys going to be able to make these redactions between now and tomorrow morning?
She already did them. She did them while you're on the record.
Outstanding, great. So let's have that in and make sure everybody's got a copy of it so they can make sure the redactions are done correctly. And then we'll give it to Mrs. Winnie to be marked. Great. You're welcome, Mr. Osler.
I know previous cases that have done not limited closing. Duration of closing is not limited in the past.
I have not done that in the past.
I would ask the court limit to an hour for each, so we can finish in a day. If we each have an hour, we can finish it on Monday, as opposed to breaking and then restarting again on Tuesday.
Your Honor, the state
Well,
has.
first of all, do the other defendants agree with that?
Yeah. Your Honor, Mr. Conrad posted it on his file, so I have to
If it was,
Mr. Brickman would agree to that.
so, yeah, but he's left it to you to make these decisions, Mr.
Right, he'd agree to that, that's fine.
Oh, he'd agree to it?
Yeah.
Mr. Conrad?
I can talk fast, but.
No. Then the court reporter has a nervous breakdown. Well, I can tell you that when, it could have been shoplifting or dancing with a mailman, whatever charge you want. I would have taken at least 90 minutes, no matter what the case was. That was tend to be my deal. And so you proposing that the state gets an hour rebuttal as well as an hour of opening? Or they get a total of 1 hour to be
We
divided?
get a total of 3 hours for opening, since we have 3 defendants, and they each get an hour to talk about their case.
Yeah.
And then we get.
3 hours?
Then we get our rebuttal.
That's exactly what we're proposing, Ms. Judge. I don't want to sit here for 4 hours and listen to Ms. Eads talk and say the same thing over and over again, and then get up and rebuttal and do the same thing, right? And so, this case isn't that complicated.
Well, I can understand why you don't want to do that, but I don't think we're going to do that. I guess the deal is, if I think that it's getting redundant, first of all, we have to understand, lawyers usually, in my experience, do not have a goal of putting the jurors to sleep. There is that risk that it happens anyway, but usually that's not the goal. It's hard to persuade somebody who hasn't heard what you've said because they've just tuned you out. So that provides a certain internal clock for people to do what they need to do. Having said that, one of the things I learned about when I ran for public office was running for public office and being a lawyer are very different things. And the amount of attention time that you have as a candidate with the voter, because they can turn you off whenever they want to, is small. But it's a very good lesson to lawyers to learn that you're not paid by the dollar, truly, when you're trying to persuade people. So they may run against their own best interest, but at this point in time, I have no intention of expressly limiting anybody's opening, and it may well be that it runs to 2 days. I kind of figured it would.
One of the reasons I bring it up, Judge, is multiple times when I've tried cases where the break closing up, meaning I would give my closing as a defense attorney, and then we'd recess and rebuttal either morning. The jurors every time commented that that was very much a disadvantage to defense, and so
Sure.
I prefer it all in one day. I understand if it doesn't happen.
Well, there are people that say, first impressions matter and last impressions matter, and all the stuff in the middle is filler. And, that's the risk the defense runs because they've got the burden of proof, so state gets rebuttal. Now, I'm not going to necessarily limit anybody here. But I do sort of reserve the right at some point in time, if this is really getting awful, to give everybody a break and say, where are you going with this? Because it's absolutely running into the ground. And that isn't necessarily meant as a criticism. It's really meant as a pointer. Because if you're losing me, you're losing them, probably. anyway, but no, I've got, at this moment, just like with jury selection, I don't have any pre-set time limits for you. We go as long as it takes. But I always reserve the right to cut you off and say, okay, 5 more minutes and we're done. Right. But you'll know that you got 5 more minutes. I'm not going to just say, I've heard enough. Next lawyer. All right. Okay, is there anything else we need to talk about before I see you guys tomorrow morning? Regular time. If we get done early, that would be fine. But this is, it's going to be a public courtroom, but not a televised or it'll not be on the record. So it's not going to be a televised event. This was on the record, so this was televised. And of course, when we do exceptions hopefully on Friday afternoon, that will also be televised.
You still want to wear a suit and tie though, right?
You can come as you however you want. I'm not a stickler for that. You don't have to wear a suit if you don't want to tomorrow. I mean, just as long as nobody gets arrested for some kind of lewd, indecent conduct. Arbenz is the guy we need to worry about. Arbenz is going to come in here with his sandals, with his socks on, his cutoffs. Yeah. Friday afternoon. Yeah.
So you have to be a Friday afternoon.
Okay, we're at break.